Okay, you can also apply measures to compulsory supervision orders and to interim compulsory supervision orders. In fact, there has to be at least one measure applied to an order. But I think what SDRA are going to do is they're going to put a standard measure on, for example, the child shall comply with the advice and guidance given by the social work department. But you can put whatever other measure you want on the supervision order, and they're basically really just the same as conditions that you would have put on a supervision requirement. The second one's quite interesting, which is actually specified, is authorise appropriate restriction of liberty, which is a sort of curfew type thing, which is fine, but I'm not quite sure how you monitor it and enforce it. But I mean, the others are just exactly the same as the condition. So basically your decision making doesn't change greatly, although the words that you're using are changing.
So the appropriate restriction of liberty is different from a movement restriction condition?
Yes, yeah. I mean, I think the movement restriction condition is the tagging.
It doesn't necessarily have to be, it doesn't need to be tagging.
Well, it doesn't have to be, but it's intensive support and monitoring, and usually has a movement restriction condition with it. But the authorised appropriate restriction of liberty might just be to say the child shall be at home from 10 o'clock at night until 7 in the morning or what have you, which you can put on at the moment. As you say, it's the matter of how you enforce that. Hearings will no longer appoint legal reps as such. What this hearing did was, they said, we don't think that the mother can effectively participate in a future hearing, and we don't think that she will, off her own bat, go and see a solicitor. So they asked the reporter to get in touch with the Scottish Legal Aid Board to ensure that she had a solicitor for the next hearing. That is the process now for legal representation. Does that make sense? Mm-hmm. So if you're in a hearing and you think a child or a relevant person can't effectively participate, you don't think they'll go and see a solicitor, you ask the reporter to notify the Scottish Legal Aid Board, and then that kicks in the legal representation. Pre-hearing panels replace and extend the provision of business meetings. So that is what pre-hearing panels will be asked to consider. Whether to deem someone a relevant person, whether to excuse the child or relevant person, and whether the hearing is likely to make a supervision order with a secure authorisation. The reason for that is that that kicks in the legal aid provisions so that the young person would have a solicitor when they came to the hearing. They may appoint a safeguarder, or they could facilitate legal representation, or they could suggest that somebody else needed legal aid. Now, it's interesting, at the moment, the reporter can make decisions about whether or not somebody is a relevant person, or can send out notifications to people on the basis that they may be relevant persons, and then that is endorsed by the hearing. Under the new Act, the reporters have no discretion to make or to notify anybody as a relevant person. The only people that can make somebody a relevant person under a certain criteria that can deem them a relevant person is the pre-hearing panel. Right, this is the definition of a relevant person. So it's going to be any birth parent, whether they're married or not, which I think is a step forward. So that includes all the unmarried fathers. Any person who has parental rights and responsibilities. And this is the interesting criteria. This is under section 81. I remember that section. Any person who has or has recently had a significant involvement in the upbringing of the child. And it's only a pre-hearing panel that can, or a hearing on the day, that can deem somebody under that criteria. I think the important word is the upbringing. Mm-hmm. It's not about grandparents who maybe see the children every weekend or have regular contact with them. It's about somebody in the child's life that is actually making decisions about their upbringing. So it's about, you know, sharing decisions about maybe schools, education, medical treatment. It's not just having face-to-face contact with them. It could be a stepfather who's living with the mother. That's the most straightforward one. And they're caring jointly for the children, including decisions round and about where they go to school, what medical treatment, etc. they're getting. Upbringing is the really important word. I mean, the example that we had in the road testing, and we didn't script somebody to do this. It was actually really quite good. We were talking about whether this particular person who had actually split up with the mother should still be a relevant person. And she was saying, well, you know, he sees the kids twice a week. I phone him if I need to make a decision about the child's dyslexia. Or, you know, I phoned him to discuss which secondary school I thought the child should go to. So he, although he's not living in the house, he's still making quite a contribution to that child's upbringing. Criteria for excusing the child and relevant person. The criteria for excusing the relevant person doesn't change. It's unnecessary or unreasonable for them to be there. For the child, it's a Schedule 1 offence and their attendance isn't necessary. This is new, and that is the attendance would place the child's physical, mental or moral welfare at risk. So that's a bit more specific. And taking account of the child's age and maturity, the child would not be capable of understanding what's happening at the hearing. So that covers the children that are too young to participate. I mean, at the moment, you know, you had to try and demonstrate that there would be distress to the child, and you know, if it's a baby in arms, really, it's very difficult. Children and relevant people will be invited to pre-hearing panels, but they're not obliged to attend. So that might affect the way that you do the introduction. So you don't need to formally excuse somebody, but if a child or relevant person isn't there, you might want to check with the reporter that they have been told that it's happening. One thing I don't know, and we're in negotiation at the moment, is what information you'll get at a pre-hearing panel. Because you can't, obviously, if somebody's asking to be a relevant person, you can't send out all the reports, because they would then have reports and they might not be a relevant person, so they would have information they're not entitled to have. So we're still discussing with SCRA what sort of information you will have.